I need control. Happy Wednesday, everybody. How's everybody doing? This is Adrian with PrepAgent, and we're getting ready to rock and roll here. Can everybody hear me? Everybody, anybody? Hey, Jasmine. Hi, Cynthia. Welcome. Hello, Anne. Great to have you all here. Excuse the scratchier than normal voice. I've got a little spring cold, so I'm excited about spring too, but yeah, spring colds are kind of the worst. Not really my favorite. So today we are doing property ownership. Everybody ready to go? All right, we got lots of thumbs up. So let's start with types of property. We're gonna touch, yeah, allergies, right? Kind of the worst things about spring. We're going to touch on a bunch of things that came up during the question feedbacks a lot this week. Go ahead, Abby. What do you got? Oh, I saw that. We're going to be doing property transfer rather than contracts today. If you check your webinar schedule, you'll be able to see when contracts are going to show up. And for those of you, I'm not sure if Joe mentioned it on Monday, but the reason that we didn't have a webinar yesterday is so that we could, property ownership. We did contracts on Monday. Abby, you can watch the replay by clicking on the link from the webinar schedule. And I'm not sure if Joe mentioned it, but we're going to have a webinar on Saturday for those who don't get to come to them very often during the week. So that will be pretty exciting. A little weekend webinar. I'm sure Joe will be in full force for that. So today, let's go ahead and start with property. What are the two types of property that we deal with in real estate for the most part? What do you guys got? Two types of property that we deal with most in real estate. Real and personal, real and personal. That's a good call too, Mike, but what we're talking about today is more real and personal property. Does anybody want to throw out the difference between those two? What's the difference between real property and personal property? Summer, I think you might be talking a little more about estates. Kashim has got on the right track there. Personal property movable, real property attached or immovable. And a lot of times we like to say that real property is generally immovable, goes with the real estate, right? Personal property is generally movable, goes with the person. Why do we say generally? Joe always says to be careful of absolutes. There's almost always an exception to every rule. So as an example of that, can anyone name a type of personal property that becomes real property? When a personal property becomes real property, what do we call that? Pool cover is along the same lines. That's exactly what we're talking about. But fixtures is more what I was looking for here. Just what they call it in real estate when personal property becomes real property. That's right. There you go. Everybody's on the right track now. So what's the acronym that we use for the test to check if something's a fixture. Rosanna's way ahead of me there. Maria. Maria, can everybody tell me what Maria stands for? What does Maria stand for? Stud muffin for sure. Method, we got one. M for method. A for adaptability. R for, what is R for? Relationship, intention, and agreement. Mike first on the board with all five. That's how we test if something's a fixture. And remember, the reason we're talking about fixtures is because they're an example of personal property that can become real property. So can anyone name an example of personal property that's actually immovable? Personal property that is immovable. What do you guys think? Anybody got any ideas for personal property that is immovable? Microwave could be immovable. Chandelier would be more of a regular fixture. Yeah, Joe stumped me with this one earlier. So I'm right there with you guys. Think business. What's a type of personal property that's immovable? Right on, Amanda, you got it. Trade fixture. And I'm just bringing that up as sort of the concept. Dentist chair is a great one. Just kind of like nailing in these concepts a little bit and what the differences are, and also nailing home the idea that there's an exception to these rules as well, right? So that's why we say that generally these things are immovable and movable. Ooh, pizza oven. That kind of makes me hungry. It's a little late in the day. I'm ready for that. Let's move on to types of ownership. So there's two main types of ownership. Has to do with the number of people involved. Can anybody throw those out for me? Two types of ownership that have to do with the number of people involved. What do you guys think? All right, everybody's off track. Pizza. Let's get back on track. Amanda is on point right now. Concurrent and severalty. Exactly. Concurrent and severalty. Severalty is which one? What is severalty? How many people are involved with severalty? Singular. Severalty is one person or entity involved in that ownership. So concurrent is more than that, right? Ownership by multiple people. There are two types of concurrent ownership that we talk about most here for your exam. There are more than that, but we don't really get into that because they often deal with marriage and that varies state by state. And we're going to stick to the things that are more pertinent to the national exam. So Sherry's way ahead of me right there. Joint tenancy, and Malfred's right behind with tenancy in common. Off. That's awesome. Thanks, Joe. Appreciate that. Working on it. So joint tenancy, what are the main, what would you say? What are the main differences of joint tenancy, or what are the main points of joint tenancy? Pillars, thank you. What are the main pillars of joint tenancy? Title is one for sure. And the other TIP. TTIP, time, title, interest, and possession. And a lot of people are throwing out the other one that's really important too, and that is survivorship. So there's something else that came up a lot in question feed, like several times this week. So let's stop and touch on that real quick. And Joe threw out like a really good analogy for it to me earlier today. So Art, Joe, and I all own property as joint tenants. We paid $300,000 total. So each of us paid $100,000 for our joint tenancy in a property. If Joe sells his interest to his brother for $100,000, what type of ownership does Joe's brother have? Anybody have any idea what kind of ownership Joe's brother would have? So we all start off by owning as joint tenants, 3 of them. Joe sells his ownership stake to his brother. What type of ownership does his brother have? Tenancy in common, exactly. That's something that seems to throw a lot of people for a loop. But you guys are doing great. Everybody's right on point with that. And so just to elaborate on that just a little bit, he's now a tenant in common because he doesn't share the unity of time with everybody else, right? Art and I would still have all 4 of the unities in common. But Joe's brother is now newer to the interest than the rest of us. Therefore, he is TTIP no longer. Exactly, Natalia. So what's kind of the main difference? That's one of the main differences with tenancy in common, not having the unity of time. What's the other main thing? There, Paula, what happens when only one person is left standing? Well, if it's Art or I that pass away, then we would be owners in common with Joe's brother. And if Joe's brother was the one, well, I mean, I think at that point, we would be, oh, then it is severalty, right? Never mind. Joe's got that if there's only 1 point left. I kind of got a little too complicated with that one. So I'm going to get back to tenancy in common. The main difference there is the right of survivorship, and Kashim threw that one out. It's kind of one of the main differences. There's no survivorship, and you don't have the 4 unities that apply with joint. So another quick question is, if you share ownership with a corporation, what type of ownership would that have to be? What do you guys think? If you were to share ownership with a corporation? Ashley says in common. Why is that? Why would that ownership be in common? Why can't you be a joint tenant with a corporation? Partners is part of it, but Amanda is a little bit more on it, and Mike is right on it. A corporation never dies. Awesome. Well, you guys are killing it with those concepts. So one of the last things that I want to touch on before we get into questions, switching gears a little bit, but also really important, is liens. What's everybody's favorite refrain about liens? What do you use to remember what a lien is? What is a lien? I don't really want to think that corporations always win, Reggie, but you're probably right about that. What exactly is a lien? Money, lien money, lien money, lien money. Money owed is another way of looking at it. So what are some of the types of liens? Well, you've got general liens. Can anybody tell me what a general lien is? Sherry already beat me to the other one. Specific lien, which is attached to a specific property. What's a general lien? What do you guys think? Those are some great examples. But general takes everything that a person owns, or they can attach to everything that a person owns, all of their assets. And like a lot of you guys called out, those are things like income tax and judgment liens. Specific is, like Amanda shouted out, property tax, mechanic liens. A bunch of people leaned on those as well. And a lien is a type of an encumbrance, but not all encumbrances are liens. So what's an example of another type of encumbrance? Can you guys think of another type of encumbrance besides a lien that we deal with in real estate? It also has to do a lot with property ownership. Bam, Malfred is on it. Easements. Easements, permission to do an act or perform an act on another's land. Easements are a type of license. And when you're dealing with easements, a lot of times you have a dominant tenement and a servient tenement. Anybody want to tell me the difference between those? Absolutely, Anne. An encroachment is another type. But with dominant tenements and servient tenements, anybody want to tell me the difference between those? Dominant gains, that's a really good way of looking at it. Kashim, that's a lot of times how we break it down. A dominant walks over the property and a servient is the one being walked on, right? Another way that we break that down a lot on the site is that a dominant tenement is the one benefiting and a servient tenement is the one being burdened as well. So right before we get into questions, what are some types of easements? I see Badma already threw out a pertinent. That's definitely one of them. What are a couple other types of easements that we deal with a lot in real estate? What do you guys think? We've got a pertinent already on the board, prescriptive and gross. That's it. A pertinent, we generally say, goes with the land. Prescriptive easements. Well, what do you guys think? You guys want to tell me what you think? What makes a prescriptive easement? What is sort of the main factor? Congratulations, Lee. That is awesome. Love you too. Way to kill it. Time. Amanda's on that. Prescriptive easement usually has to do with time. And what about gross? That's a little bit more difficult to break down, but what do you guys think is sort of the main thing that defines what a gross easement is? Utilities is a great example, Katie. Paula, what we're talking about is with a prescriptive easement is it's something that's developed over use of somebody else's property by time. With a gross easement, you see a lot of people throwing out utilities, and that's kind of like a great example of it as well. But the way that Joe broke it down to me, and I think it makes the most sense, is that there's no dominant tenement with a gross easement, right? So that's why you're talking about like a utility isn't crossing over your land to get to their land. They are getting onto your land to perform a particular activity that has to do with the benefit of everyone. Right. I see Joe is hitting that for you, Amanda. I totally actually get that. I had a struggle with that as well at the beginning, adverse possession and prescriptive easement. But it looks like Joe touched on that for you. So I'm going to move on to questions. And we are going to start with telephone lines being an example of what type of easement? A, a legally valid encroachment. B, an easement in gross. C, an easement appurtenant. Or D, a non-revocable license. Kind of just touched on this a lot. So what do you guys think? Telephone lines are an example of B, an easement in gross. Pretty much just talking about that very specifically. Katie, an easement in gross is just the terminology that grants company or individual limited rights to access another's property for a specific purpose. Good job, everybody. Next question. Which of the following would be the best and most complete definition of the term encumbrance? Anything which limits or affects the fee simple title to a property. B, the use of property by a debtor to offer a creditor security for a debt. C, any action taken relative to property other than acquiring or transferring title. Or D, the degree, quantity, nature, and extent of interest which a person has in real property. What do you guys think? What's the best definition of the term encumbrance? What do you guys think an encumbrance is? Encumbrance is A, anything which affects or limits the fee simple title to a property. Something that burdens the property in some fashion, right? Kashim, exactly, it burdens the property. Moving on. Next question. A joint tenant can dispose of an interest held in real property by all of the following ways except A, will, B, lease, C, sale, or D, gift. What do you guys think? How can a joint tenant not dispose of an interest held in real property? Via A, will, B, lease, C, sale, or D, gift? And the answer is A, will. A joint tenancy has the right of survivorship, so they cannot will their property to anybody. Right. And in a pertinent easement, the party that benefits is known as A, the dominant tenement, B, the leaser, C, the lessee, or D, the servient tenement. Just touched on this as well. Paula, can we elaborate on which a little bit more? The last question. Okay, we'll go back to that in just a second, Paula. And everybody's got this one too. And in a pertinent easement, the party that benefits is known as the dominant tenement. Okay, Joe, it looks like he's got you, Paula. So within a pertinent easement, the party that benefits is the dominant, and the party that is burdened is the servient tenement, like we just talked about. All right, let's do a story problem because you guys are killing it on all the definitions. So Nelson owns 2 acres of land. He sold 1 acre to Andy and reserved for himself an appurtenant easement over Andy's land for ingress and egress. Andy's land, A, can be cleared of the easement when Nelson sells the withheld acre to a third party. B is the servient tenement. C is the dominant tenement. Or D is subject to an easement in gross. What is Andy's land in this situation? What do you guys think? Andy's land is B, the servient tenement. It is the one burdened by the easement. Nelson walks over Andy's land, therefore his is dominant. Paula, definitely send us a message through the site and I will get back to you ASAP. All right, let's move on to Teddy and Andy. Teddy, Teddy, Andy, and Peter. There's three of them. Teddy, Andy, and Peter are joint tenants owning a parcel of land. Peter conveys his interest to his longtime friend Dan. After the conveyance, Teddy and Andy, A, become tenants in common, B, become joint tenants with Dan, C, continue to be joint tenants with Peter, or D, remain joint tenants owning a 2/3 interest. What do you guys think? What are Teddy and Andy after this? This is kind of the opposite of the example that I gave you when we were going through the concepts. Teddy and Andy coming in and out. Sorry, is that my volume? Coming in and out? Sorry about that, guys. Is that a little bit better? Okay. So what did we decide here? This looks like it's a little bit sticky for some people still, but Teddy and Andy in this case, D, remain joint tenants owning a 2/3 interest. Dan, the longtime friend, becomes a tenant in common because he no longer shares the unity of time with Teddy and Andy. His ownership is a lot newer. Does that make sense to everybody? Why Teddy and Andy remain joint tenants? Yeah, sorry about the crackle. I was just trying to make my connection a little bit better. So let me try and elaborate on this a little bit more. With joint tenancy, like Reggie just called out, you need to have the unities of TTIP, time, title, interest, and possession. So when Peter sells his interest to his friend Dan, Dan is now a newer owner. He no longer shares the unity of time with Teddy and Andy. They've owned their interest in the property for the same amount of time, but suddenly Dan comes in and he's a much newer owner. So his ownership reverts to a tenancy in common because he doesn't share all four unities. We're going to hit up another question a little bit later that hopefully explains that a little bit better. And Mary's got it right there. If there were only two people involved, then both of those would become tenants in common. But because Teddy and Andy retain the unities of time, title, interest, and possession, they're still joint tenants. Awesome. All right, Paula, it looks like you got it now. So we're going to move on to similar concept, different question. Which of the following types of ownership cannot be created by operation of law, but must be created by the parties' expressed interest? A, tenancy in common. B, community property. C, joint tenancy. Or D, tenancy by the entireties. Which of these has to be created by the parties' expressed interest? What does everybody think? All right. Seeing a lot of people are getting this right. Joint tenancy is the type of ownership that has to be created by parties' expressed interest. And Amanda, I believe you're right with that. Tenancy in common is sort of what things revert back to as far as the government assuming joint ownership is. You have to express your interest. You have to express that you want to be a joint tenant in order to make it that sort of tenancy. And so a lot of times joint tenancy is mostly like family related because the right of survivorship is basically, giving your share to somebody else after that. If you're investing for money or you have your own heirs outside of that, probably not going to do that as much. All right. So liens. Which of the following is not a lien? A, private restrictions, B, a trust deed, D, a deficiency judgment, or, excuse me, that was C, deficiency judgment, or D, mortgage. What do you guys think? Which of these is not a lien? Private restrictions, a trust deed, deficiency judgment, or mortgage? Yeah, exactly, Brian. That's a good call. Awesome. You guys got your liens down for sure. Private restrictions. Trust deeds, deficiency judgments, and mortgages are all tied to money. Private restrictions are not. So a judgment that has been recorded would be A, an equitable lien, B, a superior lien, C, an involuntary lien, or D, an inferior lien. What do you guys think? A judgment that has been recorded, what kind of lien are we talking about? And in a question like this, you're wanting to pay attention to the most appropriate answer. A recorded judgment is equitable, superior, involuntary, or inferior. And the answer is C. An involuntary lien is the most correct answer in this case. I can see a little bit where your confusion is there, Amanda, but it is absolutely an involuntary lien. There's no question that a judgment is something that you're not asking for. And so that's what I would look at if you see something like this on your exam. It is the indisputable answer, if you will. All right, I'm going to try and rush through some of these. We got started a little bit late, and I want to give you guys as many of these different examples as I can. So in receiving a gift of a parcel of real estate, one of the two new owners was given an undivided 60% share. The other received an undivided 40% share. They now hold title as A, cooperative owners, B, community property owners, C, tenants in common, or D, joint tenants. What do you think? They received a gift of real estate, so they do share time, but they don't share interest. One has 60% and one has 40%. So what kind of ownership do they have? And awesome, tenants in common. That is how these two are holding property. They don't share TTIP, exactly. Exactly, Jasmine. Their interest isn't equal. Their possession is, and they potentially have time. Thanks, Reggie. Much appreciated. You too, Paula. That's the kind of feedback that keeps me going. All right, so let's move. What's the P, Katie? The P in TTIP is possession. So that is they share the title. Both of their names are on the title, right? Next question. An owner of a property with a lake has given the neighbor verbal permission to fish in the lake. The neighbor's right of use is most likely A, an encumbrance, B, an easement appurtenant, C, a license, or D, an easement in gross. They think the neighbor's right in this situation is C, a license. And the main difference between this kind of license, verbal permission, as opposed to an easement, which is also a type of license, is that because the license has been given voluntarily by the property owner, it can be revoked or terminated at any time. Right. Exactly, Mike. Can be taken back at any time. When a lien against a parcel of real estate may result from a lawsuit currently before the court, someone examining the public records would look for A, a lease pendens, B, the chain of title, C, a judgment lien, or D, a suit to quiet title. Stephanie, no, I don't believe you have to go to court to give your own license. Verbal permission counts. I'm sure you could if you like to, but I'm pretty sure it's not a requirement. So what do you guys think? When a lien may result from a lawsuit currently before the court. A public records, someone examining the public records would look for a lease pendens. You know, Paula, I just looked up the pronunciation before I started this, and you could be right. Maybe it's a les pendens. I know that the pendens is sort of dragged out. So oh yeah, it's spelled L-I-S, like Joe is saying. I thought you were talking about the pronunciation. And for anybody that's not 100% sure, that is Latin for suit pending, pending lawsuit. And so in this type of question, you actually see it, a lot of hints in the question as to what you're looking for there. And Joe's got it right there. Pronounce it however you want, as long as you circle the right answer. All right, we're going to bang through a couple more here real quick. The priority of liens refers to which of the following? A, the order in which liens will be paid if property is sold to satisfy a debt. B, the dates liens are recorded. C, the order in which a debtor assumes responsibility for payment of obligations. Or D, the fact that specific liens have greater priority than general liens. The priority of liens refers to which? And this one can be a little bit tricky. What do you guys think? The order in which liens will be paid, the dates they're recorded, the order in which a debtor assumes responsibility for payment, or the fact that specific liens have greater priority. You guys think? I see mostly A's, which is the correct answer. The order in which liens will be paid. The fact that specific liens have greater priority than general liens is something different than priority of liens. And that's something we can get into it another time. That's not coming to me right at the moment. But if you want to message me that question, I'll get back to you with an answer on that one, Nicole. All right. This one came up several times this week too, so I wanted to touch on this before we're done. After real estate has been sold by the state or county to satisfy a delinquent property tax lien, if state law permits, the defaulted owner has a right to A, pay the creditors directly and have their liens removed, B, record a notice of non-responsibility for the unpaid taxes, C, have the sale canceled by paying the back taxes and penalties, or D, redeem the property within the time specified by law. What do you guys think? After real estate has been sold by the state or county, if state law permits, what does the owner have a right to? Awesome. So you guys are on top of this. You're obviously not the ones that were sending me questions about this during the week, but the right, I believe it's the equitable right of redemption is the right that somebody has when their house is being foreclosed on to redeem the property within the time specified by law. Totally agree, Mike. It's a huge mouthful. As far as the time specified by law, that varies state to state. So that's something that you guys can look up and get answers to that, like sort of individually. But that's going to be it, guys. We got to get out of here for today. So Joe will be back tomorrow at 10 o'clock. And thanks, everybody, for joining. Much appreciated. We'll see you guys next time. And I hope you have a fantastic evening. Thanks again.